Okay, fantastic. We made it to 10 a.m. Um, Hello, everybody. So we are going to start with our keynote speaker, David Lott. Um, a quick bio of our speaker. David Lott is a trailblazing legal luminary whose dynamic career has spanned from being a federal prosecutor to becoming a celebrated writer and commentator on legal affairs. As the co founder of Above the Law, one of the nation's most frequented legal news websites, he significantly influenced the legal media landscape. His incisive wit first came to prominence with Underneath Their Robes, a blog that offered an irreverent look at federal judges. David's literary prowess was further established with his acclaimed novel Supreme Ambitions, which resonated deeply within judicial circles. A Harvard and Yale Law alumnus and a former litigation associate at a prestigious New York firm, he has also earned recognition for his courage and service to the community, particularly through his transparent account of his battle with the severe case of COVID-19. His numerous accolades include being named an American Lawyer Attorney of the Year finalist, receiving the National LGBT Bar Association's Dan Bradley Award, and selection as an ABA Journal Legal Rebel, among other honors. David's personal triumphs and professional contributions make him an intriguing figure whose influence extends well beyond the courtroom and into the heart of society's discussions on law and justice. So, David, I am so thrilled to have you here with us today. Um, do you have access to all the controls you need?
Yes.
Okay. And then let's see. We need to make sure that yours is the only face that we can see. David Holt, please help. All right. Looks good.
Okay,
I'll
great.
leave it to you.
Can everyone hear me okay? I have to apologize. Our generator seems to be going off. So I hope you can all hear me. If not, please just say so in the chat and I'll try to relocate to some other part of our house, but I try to be fairly loud. So thank you, Bianca. It is really a pleasure to be speaking here at the Spring Institute. And at the risk of pandering, I always enjoy speaking to law librarians. I've spoken in the past at events sponsored by the American Association of Law Libraries, and with apologies for trafficking in stereotypes, I've always found librarians to be an extremely thoughtful and attentive audience. So I'm going to try to actually speak fairly quickly because I want to leave a lot of time for a Q&A today, especially because when I've spoken about this topic, there have been tons and tons of questions, and I always benefit really most from the Q&A, where I get to hear the perspectives of people from around the country. So I'm going to try and actually keep my prepared remarks not too long. So, in terms of my topic for today, I'm going to be talking about free speech and civil discourse in the legal profession. And when I was chatting about this with Bianca and Taryn, I thought it would be a good topic for two reasons. First, it ties in very well to the theme of this year's Spring Institute, the state of the legal profession. And secondly, it is timely and topical in terms of the news cycle beyond the legal world, going well beyond the legal profession to touch universities and workplaces around the country. As of today, I believe more than 500 people have been arrested at protests relating to the Israel-Gaza conflict at university campuses around the country. So this is a topic that's being talked about in both legal and non-legal circles. I'm going to focus my remarks on the legal profession, however, for two reasons. First, it's what's most germane to you as law librarians and to the theme of this year's institute. And second, it's because I am a bad pundit. I am the rare pundit in 2024 who believes in staying in my lane. And in contrast to how everyone on social media became a public health expert during the pandemic, and now everyone is a legal expert because of the Trump cases, I try to stick to speaking about things that I have some information about. And I do know about free speech and the First Amendment and the legal profession as somebody who's been working in and writing about it for 20 some years. And so I do think that I will try to keep my remarks focused on the legal world, although perhaps in the Q&A we will extend a little bit beyond, but with the caveat that I have no particular special knowledge about fields beyond legal. So let me explain how I come at these topics. although I do understand them as a lawyer, I come at them more as a journalist. And although I founded Above the Law and was there for more than a decade, my primary outlet these days is a newsletter on the Substack platform called Original Jurisdiction. It's kind of like a more serious, less funny version of Above the Law, I guess. I left Above the Law 5 years ago, so if anything you've read there recently has made you mad, I had nothing to do with it. And when I started Original Jurisdiction, I thought I was going to write mostly about a lot of the topics I covered at Above the Law, like law firms and the federal judiciary. But what I've wound up writing a lot about are free speech controversies at both law schools and law firms. So, for example, in terms of controversies at law schools, there was a protest of conservative litigator Kristen Wagner in March 2022 at my alma mater, Yale Law School. And in March 2023, a little closer to your neck of the woods, there was a shoutdown of conservative Fifth Circuit Judge Kyle Duncan. That was in March 2023 at Stanford Law School. I've also covered similar controversies at law firms, including the ouster of Paul Clement from Kirkland and Ellis over his work on behalf of Second Amendment clients, and also the departure of Robin Keller from Hogan Lovells over some views she shared internally at the firm over the Supreme Court's decision in Dobbs. So as a result, I've been writing about and covering these topics for the past 2 years, and I've been speaking about them also for roughly the past 2 years. And this talk has been a work in progress. I've constantly been changing it and tweaking it because for the longest time I kept on updating it to take into account recent events. And I was often updating it in a way that was perhaps depressing to include the latest unfortunate controversy at some law school or some law firm. Now I think the picture is a bit more complicated for speech in the legal profession, and there might even be some reasons for cautious optimism, which I will get into. But before diving in, I want to share a little bit about where I'm coming from politically, which I think people often view, and I would argue incorrectly, as related to free speech. In college and law school, and in my early years as a lawyer, I was very conservative politically. But over the years, my views have shifted and changed on a lot of issues. And today, even though I'm not registered with either political party, I would describe myself as closest to a mainstream Democrat. I would also describe myself as a lowercase l liberal with a very strong commitment to free speech, intellectual diversity, and civil discourse. And this is partly because of my own ideological evolution, which would not have been possible without my having been exposed to so many different viewpoints on so many different issues, which allowed me to weigh the arguments and make up my own mind. So I get frustrated when I hear free speech described as a conservative or right-wing cause, because I don't think it is. We all benefit from free speech. We all avail ourselves of it. And in my own case, free speech and being exposed to diverse viewpoints led me to move more to the left. For other people, this type of exposure has led them to move to the right. But in a democracy, it's very important for our self-government. And in a free society, it's very important for us to educate ourselves and make up our minds about the key issues facing our communities. Now, I will say that in certain environments, such as the campuses of certain universities, protecting free speech has been more to the benefit of conservatives, which is why I think sometimes it's seen as a right-wing cause. In my view, free speech just benefits whoever is in the minority or doesn't control the levers of power in a given environment. And I think whoever is in power will frequently attempt to curtail the speech of people who disagree with them. So that might be the campus left in higher education, or it might be Governor Ron DeSantis in Florida from the right. So again, I don't see free speech as a partisan issue, and I'm going to get into that a little bit more later on in my talk. So let me now turn to where I think we are in terms of speech in the legal profession. Last fall, last October, we were all horrified and saddened by the Hamas attacks on Israel on October 7th. And in the wake of those attacks, law schools and law firms around the country have been racked by fierce conflicts over speech. These conflicts have been terrible in a lot of ways, especially for Jewish students who have faced a well-documented rise in anti-Semitism. And that is now, by the way, the subject of multiple lawsuits alleging the fallout from the attacks and the controversies over speech have had a more complex effect on the speech climate in the legal profession. And not all the changes have been bad. I'm going to outline a few here right now. First, there has been an exposure of inconsistent approaches to speech depending on the content of the speech. I wrote about this in an original jurisdiction post entitled Against Free Speech Hypocrisy, where I commented on the testimony of the three university professors who appeared before Congress to talk about their institution's responses to anti-Semitism. In their remarks, the president generally stressed that even though they are private universities, they follow the First Amendment, and as a result, they don't punish speech, including anti-Semitic speech, until it turns into actual conduct, which can include things like harassment. So speech can verge into forms of conduct. But the presidents were called out in the wake of the hearings, and during the hearings, actually, for how they have allegedly not punished anti Semitic speech. And that's again alleged in various lawsuits against various institutions. But they have cracked down on speech regarded as hostile to minority groups other than Jewish students. And as a result, two of these university presidents actually lost their jobs. So I think that this is one consequence, an exposure of these inconsistent approaches to speech depending on content, which is really opposed to the principles of the First Amendment, which is supposed to be content and viewpoint neutral. So I'm hopeful that going forward, universities will be more content neutral when it comes to enforcing their own speech policies. Second, and this is related to what I just discussed, but I think it's a discrete point. I think we're going to see fewer institutional statements about hot button issues of the day. For a number of years, and especially since the murder of George Floyd in 2020, law schools and law firms have been issuing statements on numerous controversial issues of the day. Most of these statements have adopted the progressive perspective on the issue at hand. So what is the problem with these statements? I think for educational institutions, they harm the mission of a university. As noted by then Dean of Stanford Law School, Jenny Martinez, she's now the provost of Stanford Law, in a memo she issued after the Judge Duncan protest, statements from university administrators on controversial or contested issues of the day tend to enforce what she called an institutional orthodoxy on these matters. So let me give an example. Say your university president or your law firm managing partner issues a statement lamenting or criticizing the Supreme Court's decision in the Students for Fair Admissions cases, the affirmative action cases, which held unconstitutional racial preferences in education. Let's say you're a faculty member who was doing research in this area and your research found that affirmative action was not helping minorities. Or say you were a student who wanted to speak out in class discussion to criticize affirmative action. You can see why a faculty member might be chilled in terms of their research agenda, or why a student might be chilled in terms of what they want to contribute to class discussion if the head of the entire university is speaking out against these Supreme Court decisions and in favor of affirmative action. So I'm going to quote from the University of Chicago's Calvin Report. This was a document, a great document in the area of free speech. It was commissioned in 1967, which was another time of great upheaval and unrest on university campuses during the Vietnam War era. And the Calvin Report was commissioned by the university so that they could develop standards for deciding when the university would issue statements. And here's just the quote I'm going to read from the report. I would urge you to Google it and look it up online. It's a very short report and it's very interesting. So here's the quote. The university is the home and sponsor of critics. It is not itself the critic. It is a community of scholars. A university, if it is to be true to its faith and intellectual inquiry, must embrace, be hospitable to, and encourage the widest diversity of views within its own community. So now let's take that and return to the October 7 controversy. There were a number of university presidents, including some who testified before Congress, who were either slow to issue statements about October 7 or issued tepid statements or both. And when they were criticized for this, some of the university presidents invoked the idea of institutional neutrality, like what I just described with the Calvin Report, saying that, look, it is not our place as an institution to weigh in on these issues about which our stakeholders disagree strongly. But the university presidents, I think, were properly called out at that point for how, in the preceding 4 years or so, they had issued numerous statements on everything from the murder of George Floyd to abortion to affirmative action, et cetera. Law firms, I think, also have similar concerns about institutional statements. I think this is especially true of so-called big law or large law firms with hundreds or even thousands of employees, where an ideological perspective is not part of the brand. And I'm going to get into the idea of firms where maybe an ideology is part of the brand in just a sec. But research has shown that diversity produces better results for clients. And that diversity includes not just racial and ethnic and gender and sexual orientation and socioeconomic diversity, which I think are all important forms of diversity, but it also includes intellectual diversity. So let's say your law firm has a Supreme Court practice. It's helpful to have conservatives on your team who might better understand how to appeal to conservative justices. And you might not like that we have such a conservative Supreme Court, but that is the reality, and your clients are depending upon you to appeal to and persuade these justices. So again, for similar reasons from the university context, I think it's preferable when law firms aren't weighing in on every issue of the day, because some of that could alienate employees who might not agree with the view being articulated. And by the way, I will say this also applies, I think, to some of the statements that law firms have issued about October 7. Some of them have signed on to a letter that has been very critical of anti-Semitic speech. And again, I'm very supportive of criticisms of anti-Semitism. My husband's Jewish. We're raising our two boys Jewish. I'm very concerned as a parent to imagine them someday at an institution of higher learning that might be plagued by anti-Semitism. But I do question whether it is the place of law firms to wade into these highly charged issues about which you might have some people who are very pro-Israel and some who are pro-Palestine. And as long as their views don't verge into any kind of harassment or misconduct towards their fellow employees, I think law firms should tolerate a broad range of views on the current conflict. So what do I predict as a result of these controversies? I do think that leaders of universities and companies and law firms and other organizations are going to be a little more cautious about issuing statements, which I think is a good thing. In the past, there was very little incentive not to issue a statement because generally, if you issued a statement, progressives would be happy and conservatives would just kind of deal with it because that's just kind of how it's always been at a lot of institutions of higher learning or large law firms. But I think the Israel-Palestine issue was a bit different. It is an issue that people have very strong feelings about on both sides, and you have significant constituencies on both sides. In universities, for example, students and faculty tend to be more pro-Palestine, alumni and donors tend to be more pro-Israel, and university leaders learned very quickly the costs and the downsides of issuing statements, which is why they had to issue and reissue these statements. So it's interesting. Here's a concrete sign of in universities becoming a little more cautious about statements. At Harvard, where Harvard Law School Dean John Manning is now serving as interim provost, the university recently announced the creation of what it called an institutional voice working group. And that working group, true to its name, is going to consider when and under what circumstances Harvard should issue an institutional statement about questions that are in the public discourse. And my own view, my own urge, again, is for there to be fewer statements. Now, look, there is obviously, and even the Calvin Report recognizes this, an exception for statements that directly impact your institution. So say you work at a state university and there is some bill about cutting funding to your university. Of course, you should be able to speak out against that. But in terms of your views on things happening on the other side of the globe, I'm not that your own stakeholders disagree with amongst themselves. I'm not sure it's a place of a university president to wade into that. The third thing that I'm hopeful about in the wake of these recent controversies is that we can get rid of this idea, which I think is incorrect, that cancel culture is some kind of chimera cooked up by the right wing. And why do I say that? I think that instead of conservatives getting canceled, now people on the left are getting so-called canceled for pro-Palestine views. So I'll give you an example from the world of law firms. There was an associate at Sidley Austin who was fired after she wrote a post on Medium that was, I think you can fairly say, very pro-Palestine and very anti-Israel. But unlike others who lost their jobs for pro-Palestinian speech, this associate did not write anything that could be construed as pro-Hamas or pro-October 7. And in fact, at the very start of her essay, she condemned the October 7 attacks and said there's no justification whatsoever for them. But she said a number of things, which I guess you could say are outside mainstream big law opinion, most notably that she favors a one-state solution, a secular nation where all citizens are equal under the rule of law, regardless of religion or ethnicity. Now, again, I happen to disagree very strongly with this view. I support a two-state solution, including in Israel that is an explicitly Jewish state. But I don't view her advocacy of a one-state solution as outside the so-called Overton window of acceptable discourse. She was not advocating for getting rid of the Jews already in Israel or something by some terrible means. She was just saying we should have a society that is secular where the citizens are equal under law. And I don't think her opinion is outside the bounds of acceptable discourse. And in fact, the New York Times a few weeks ago published an op-ed basically arguing very similarly. So let me contrast this actually with another situation. This happened at Winston and Strawn, where they rescinded the job offer of the former Student Bar Association president of NYU Law after this individual sent out a very pro-Palestine message on the SBA listserv. The message went out on October 10, just a few days after October 7. And unlike the Medium post by the Sidley Associate I mentioned earlier, it could be construed as pro-October 7 or pro-Hamas, because the message opened by this student expressing their, quote, unwavering and absolute solidarity with Palestinians in the resistance against oppression, and also continued with a declaration that I will not condemn Palestinian resistance, which could be read as I will not condemn October 7. And then this person went on to say, I will, however, condemn settler colonialism and apartheid and various other things that the speaker associated with Israel. And so Winston withdrew the offer to return as a full-time associate from this individual. I think the two cases show the hard lines that employers and schools are going to have to draw. And this leads me to my fourth and final point, which is that for those of us who are in between the extremes of discourse, I think we're learning that these issues are just really hard. They pit critically important values against each other. For example, on campuses, they require weighing the right of students to free speech against the right of other students to a safe learning environment. And they even pit First Amendment values against each other. So take the situations involving law firms. As private institutions, not state actors, they are not held to the standards of the First Amendment, which restrains government. And as private institutions, they have First Amendment rights of their own. They have free association rights to associate with people who they support or agree with, or to at least not associate with people whose views they find reprehensible. So if Winston and Strawn doesn't want to associate itself with someone like that NYU law student, that is their right as a firm. And certain firms, I would say, especially in the boutique space, define themselves ideologically. They will say, we are a progressive firm, we stand up for the rights of workers, or we are a conservative firm and we stand up for religious freedom, or what have you. And firms should have the right to define themselves in that way. And on a related note, I'm just going to kind of take a little digression, but I think it's important to understand how this applies to the legal profession. While public universities are bound by the First Amendment, private universities, including private law schools, are not. Many universities have voluntarily adopted standards that track the First Amendment, but I also support respecting, as consistent with the First Amendment, the right of some private schools to define themselves according to a special mission. You see this most commonly with religious institutions. And in the case of those institutions, I think they can be more aggressive in terms of policing speech. For example, maybe a Jewish university like Brandeis or a law school like Cardoso might want to take a harder line against anti-Israel or anti-Semitic speech. And I think that's their right. I think we also should have some law schools like that. I just wouldn't want every law school to have some kind of unique mission or religious affiliation. And by the way, in another bit of positive news, I wrote about this for my column for Bloomberg Law. The ABA recently adopted Standard 208, which, as a requirement of law school accreditation, mandates that law schools have policies protecting academic freedom and free speech. And I think this is a good thing. People can have a debate about whether we should even have ABA accreditation. But if we're going to have accreditation, I think protecting the free speech and First Amendment rights of faculty and students should be a part of that calculus. And that standard, though, which I wanted to just mention, does have a carve out for religious institutions, because having institutions, having law firms or law schools with special and unique missions, I think, is also part of the marketplace of ideas. A couple of other nerdy footnotes because I'm guessing as both law people and library people, you're my people, you're my fellow nerds. So I mentioned that the First Amendment doesn't generally apply to private institutions. There are a couple of footnotes here. Sometimes there may be state laws that apply First Amendment standards to private actors. So California has something called the Leonard Law, which basically applies First Amendment standards to private, non-religious, non-sectarian universities. And then on the law firm side, even if political opinion is not protected under federal employment discrimination law, there may be state and local laws that limit an employer's ability to fire an employee. This is something that Professor Eugene Volokh of UCLA has written a lot about. For example, New York has a law that bars employers from discriminating against employees for recreational activities. And there might be an argument that writing, especially if not done for pay, like the Sidley Associates writing, is recreational. Similarly, in California, there is labor law section 1101, which prohibits employers from controlling or directing or tending to control or direct the political activities or affiliations of employees. Now, one can argue that perhaps that's more related to things like party registration or running for office, but we'll have to kind of see how the courts construe it. There is an actress, Gina Carano, who expressed conservative views on social media, and she is invoking this law in suing Disney, which fired her from a popular series that she was on. So I guess what I would say just generally on these types of issues is I interviewed Greg Lukianoff, head of the Foundation for Individual Rights and Expression, or FIRE, which is a great free speech organization. I interviewed him on my podcast, and Greg made the important point when I pressed him, saying, look, don't employers have the right to fire employees? These are private institutions. He said, look, they might have the legal right to do that, but they should ask themselves whether it's a good thing. Just because something is allowed under the law does not mean it is a good or wise policy. And Greg told me, and I'll just quote him here, our goal at FIRE is to get people to at least consider, in a way that we used to be better about as a society, old ideas like everyone's entitled to their own opinion. And this is why I would say, in other words, I would prefer to live in a world where employers tolerate a wide range of views on controversial issues. And so if I could urge any sort of concrete call to action upon all of you, I would urge you just in your day-to-day lives, whether in your workplaces, your communities, your social organizations, your families, to just try to hear out a wide range of views on controversial issues and to listen respectfully and to not impute bad faith too quickly to the other side. So returning to current events, I would say that we are in something of a free speech crisis, but as the old saying goes, a crisis is a terrible thing to waste. It is possible we might emerge from this current moment with a keener appreciation of the importance of free speech and civil discourse. For example, I think it's no coincidence that post the McCarthy era, the Supreme Court handed down a number of very important decisions protecting free speech rights. At the same time, I recognize it's possible that things could get worse. I think that we can all agree that we are at a critical inflection point, which is why I think we all need to do our part to be part of the solution in our workplaces, our communities, our families, and wherever else we might be able to make a difference. So in closing, I'd just like to share with you some words from the great Judge Learned Hand from a speech he gave in 1944 called The Spirit of Liberty. There is a religious shout out at the end, but you don't need to be religious, I think, to appreciate the wisdom of his words. And so this is what Judge Hand said in his speech. What then is the spirit of liberty? I cannot define it. I can only tell you my own faith. The spirit of liberty is the spirit which is not too sure that it is right. The spirit of liberty is the spirit which seeks to understand the minds of other men and women. The spirit of liberty is the spirit which weighs their interests alongside its own without bias. The spirit of liberty remembers that not even a sparrow falls to earth unheeded. The spirit of liberty is the spirit of him who, near 2,000 years ago, taught mankind that lesson it has never learned but never quite forgotten, that there may be a kingdom where the least shall be heard and considered side by side with the greatest. Thank you again for listening to my remarks, and I look forward to a lot of discussion.
Wonderful. Thank you so much for speaking. I loved listening to it. Thank you for all the information and insight. I think I now aspire to a higher level of nerdiness because I'm pretty sure we're not on the same level at this point. And I really love what you said. A crisis is a terrible thing to waste. That's profound. And I'm going to be using that probably strategically in a couple, messages going forward to people. I'm going to double check the chat to see if
I
okay.
do see. Oh,
Can you
go
see it?
ahead.
Okay.
Sorry.
No,
Go
no,
ahead.
please do. It's all right. I'll read out loud. Thank you for this, David. To your fourth point, just a thought that made points 1 to 3 harder for me to stomach. I appreciate seeing issues framed and discussed as more than two sides or both sides. Consistent with your fourth point, I very often do not see my voice more nuanced represented by either side. I'm sure many academics, lawyers, librarians, and general overthinkers feel similarly. However, I understand that in a historically adverse legal system, that is oftentimes the default framework, limiting in and of itself.
So that is a very fair point. And I will acknowledge, and I think that a lot of critics of modern First Amendment discourse would acknowledge that the challenge with the First Amendment is it reflects existing social inequalities. So people are going to have a greater voice if they have more money, or they own a newspaper, or they own a broadcast network, or things of that nature. I think that means that it really is incumbent upon folks, especially from historically marginalized groups, to speak out ever more strongly because your voices need to be heard. And I think that is a way to try and outweigh the inherent imbalance. One thing I will say that arguably has made things better, but then I'm going to as you can see, I'm very much like a one hand, other hand kind of person. So one thing that has made things somewhat better and somewhat worse is social media. On the one hand, I think social media has allowed for the elevation and expression of voices that were historically excluded, partly because they had no other way of reaching the world. They didn't work for a newspaper, they didn't work for a TV or radio station. So I think we saw that especially in the summer of 2020 during the Black Lives Matter movement. On the other hand, social media has also been a force for ill. It has been used for all kinds of doxing and threats, and often these threats have been directed at historically marginalized communities. So again, I think these are really, really hard issues. But I would urge you, I totally agree with the perspective, and I try to always avoid when I remember, I try to avoid using the formula, we need to hear out two sides or both sides, because most of these, I would say all these issues have an infinite number of sides, really. I mean, I think we should hear out all sides. And I think that's why people who have views that maybe outside of the mainstream or not fully represented need to speak out. And again, that's something I would urge all of you to do, to not be shy about speaking out, especially if you see something in your own workplace or your own community that doesn't sit well with you. And look, I have to admit, there are going to be costs to speaking out on issues. Sometimes you might not be as popular as you used to be. When I was writing about my COVID journey in March 2020, in the early days of the pandemic, before everything became politicized, I was sort of beloved across the ideological spectrum. It was before things had gotten political, and I got get well messages while I was in the hospital and while I was on a ventilator from everyone from Ted Cruz to Susan Rice to Cher. It was really sort of a bipartisan thing. And now that I weigh in on legal issues as I used to before the pandemic, now I get people who call me out and criticize me for this, that, or the other thing, sometimes from the right, sometimes from the left. And look, I acknowledge also, and going to your point about just kind of structural inequalities, sometimes speech comes with risks. It's very easy for me to speak out on a lot of issues because I feel that I have a platform and I feel I have some measure of job security as somebody who's self-employed rather than works for an organization. People can get fired, as we've seen. But I guess I would just say do what you can within the constraints that you face to stand up for the values of free speech and civil discourse and to make your voice heard. And again, I've rambled too much, but let me just add one other point. If you don't speak out, and you kind of mentioned that you feel your view on some issues is not represented, the discourse is just going to be hijacked by the loudest voices. So, for example, I think many of us have very nuanced views on the Israel-Palestine-Gaza issue. I mean, I'm very torn myself. I mentioned that my husband's Jewish and we're raising our kids Jewish, but our kids are actually part Palestinian ethnically because our egg donor, her mother, is Palestinian. And so, it breaks my heart to see what's going on in Gaza. Like, I think a lot of us have very complex views on a lot of these issues, but the complex views aren't being represented because you just have these extremes on both sides.
Thank you for that. Do we have the chat has been a little slow. Does anyone have any additional comments?
And feel free to ask about anything. We can talk about things not related to my talk. I'm not offended.
As long as the post from Above the Law was over 5 years ago, because we've already confirmed that anything after that was
Exactly.
not, didn't involve us.
The statute of limitations has run.
Right. Well, I'm not seeing anything. So thank you,
Oh
David.
goodness,
Thank
I
you
I
for the
feel
conversation.
I hope I haven't. I feel very oh wait, someone actually. Okay. Here's a question. Thank you. Oh, so the TikTok ban. So right now there is, of course, the wildly popular social media platform TikTok. It is owned by a company, a Chinese company called ByteDance. And because it is a Chinese company, and just given the nature of Chinese politics and economics, the Chinese government does have some influence over ByteDance. And so there has been a lot of discussion about either an attempt to ban TikTok, the app that is, or there have also been efforts to get a discussion of giving ByteDance a certain amount of time to sell the company to a user that is not controlled by again, this is in the legislation, in the draft legislation, a particular set of entities. It's interesting. I guess I'm, like I said, I like on a lot of the issues, I'm kind of in the middle. On the one hand, I totally understand the national security concerns, given the access to data. But I really don't like the idea of a ban, I guess I will say, just because this is an app that so many people, especially young people, do use to express themselves. And like anything else, like any other tool, including, say, artificial intelligence, the tool itself is just a tool. It is not inherently good or evil. I think the question is how we use the tools, or what is the potential of the tools to be misused. I think I am more understanding of efforts to have some kind of divestment. I do think it's very tricky. There have been attempts to do this before that have not worked. And so again, I do have some concerns. But again, it's a good example of just how a lot of these issues just have a lot of different complex implications. So one person raised the question that whether is the ban more trying to lessen perceived or real Chinese influence, or trying to limit the activist connectivity. That's a hard question to say, because different people have different motives for pushing this ban. And I could imagine some legislators having one set of motives and others having others. I will say, and there are a lot of, I think, distressing anti-Asian sentiments. We have seen that. I mean, that's been around forever, but it certainly spiked during the pandemic. And now there are even state laws, I believe in Florida, for example, that are being challenged, as for restricting, say, Chinese ownership of property and things of that nature. So I am very concerned about the scapegoating or demonization of either China or Chinese Americans. At the same time, I do understand the legitimate national security concerns. Maybe there is some middle path where there is some kind of audit or something if they don't find a user, an owner of TikTok that's not going to be unduly influenced by another government. So yeah, I guess I would say I'm not really willing to pronounce that everyone is acting in bad faith on the TikTok ban. I think some people might be and some people not. So one question is, do I have a position on certain moves to ban certain books in public libraries and school libraries? So as you would expect, given my own views, I find this extremely, extremely troubling. And I will point out that there have been a number of rulings in the courts concerning some of the attempts to control what is said or taught in schools. The 11th Circuit, the federal appeals court covering Florida, for instance, recently ruled against the so-called Stop Woke Act, to certain provisions of it. There have been lower court rulings about it as well. Now, again, to give the other side its due, there is established law indicating that, understandably so, public schools and communities have the right to decide what is age appropriate for children. So I don't think, I mean, whatever, to set up a straw person, like I don't think we should have Playboy, in the first grade section of the library. But, I think that the policy just has to be exercised with just much better judgment and more discrimination, and not banning things like Toni Morrison novels. I mean, I think that some of the banning has really just kind of gotten out of control. But again, I will give props to the courts. They are standing up against a lot of this. I will also point out that the Supreme Court is sort of having a free speech term right now. They have two cases that are dealing with the rights of social media platforms to moderate user content. They recently decided a case about public officials using their personal social media accounts to talk about both personal and government business. There's another case involving the ability of governments wearing their regulator hat to cajole social media companies into suppressing certain types of content. So there's a lot going on right now in the Supreme Court. I feel that a lot of the time, the free speech, First Amendment issues are kind of overlooked by the court. But right now, for those of us who are interested, it is really just kind of, just kind of fascinating. Um, so, well, this is interesting. Um, I mean, look, I do. So on the point about, whether Facebook and other social media entities are trying to engage in a kind of land grab or protect their existing advantages, I think that's certainly part of it. I mean, they're economic actors. I think we are now not naive to think that, Google is not being evil. Like, I think we all know that big tech can also have big problems. What I would say about TikTok that I think is actually something that should be kept in mind for courts that are dealing with these issues is the rapid rise of TikTok shows how quickly social media can be disrupted. TikTok came out of nowhere. You would have thought that, oh, it's just going to be Facebook and Twitter and Instagram till the end of time. And then suddenly TikTok came. And now, for some people, it's the dominant source of news. So, I do think that that is a positive sign if you believe that the existing platforms have too much power. There's a question about bias in AI for news relating to elections, and also misinformation that may have a disproportionate effect on communities of color. I agree that this is a huge, huge issue. And again, I said I didn't want to, really talk about, my above the law days, but I wrote an article, gosh, years ago, if I can pat myself on the back, about the bias in AI. And why is that? So the way AI is trained, these algorithms are trained is on existing data. You give it a data set. And the data sets that are out there will already reflect existing biases and imbalances in society, politics, the economy, et cetera. And so you have to be very, very careful to make sure that when you're designing these AI tools, they don't import all of the existing biases. Now look, I understand, I will acknowledge, like, you can you can probably, you can go overboard. Some of us may have heard about the situation involving Google's AI tool where some users wanted stock photos of popes or something like that, and we were all getting black female popes. And of course, historically we've not had women or people of color as popes. So maybe that wasn't super helpful if you're just trying to illustrate a grade school lesson about popes or something like that. So I understand that sometimes, maybe things can go too far, but I do think that a lot of the attempt to root out bias in AI is well intentioned, and I think it's very, very important.
Thank you. Thank you for all the information and your comments. Thank you so much. And thank you everyone for the fantastic questions. Just the information just keeps flowing. It just keeps coming.
And
So
I
thank you
would,
so much.
if I can include one last plug, I love to connect with people on social media. Feel free to connect with me on LinkedIn, Twitter, Facebook, Instagram, Threads. I'm on all of them to varying degrees. And if anyone wants a free subscription to my newsletter, just email me, davidlat@substack.com, subject line complimentary subscription, and I will set you up. Again, I really appreciate your having me. It's been very, very kind of you, and I've greatly enjoyed the conversation.
Thanks. And we are so happy that you were able to speak with us. Thank you so much. And you're welcome to stay for the rest of the conference or take off. Thank you.
Hey, thank you. Hey, thank you.
And for everyone else on the call, as promised, we have a 15-minute silent break. So go check on your pets, go check on your kids, check on your email, go check all those things. You have 15 minutes, and then what time is it? Okay, and then at 11 a.m. Pacific Standard Time, we will continue with our next speaker. So thank you.
Unmuted.